So the topic is patent search and patent analysis. So I think, Dr. Vinita, you've given me a feedback that people who have joined this FDP do not
Mm.
have deeper understanding of patent searches, and so we will cover little less the patent analysis, but we'll focus on basic searches. So
Mm.
what I will, about 20-25 minutes, I will run through my slides
Mm.
and explain different aspects of patent search and patent information. And then, as you have made a provision of hands-on, so I will really demonstrate a hands-on session
Very
using four sources of patent information, particularly
excellent.
Indian. Okay, thank you. Indian Patent Office website,
Mm-hmm.
then USPTO, and there's a mother source of all patent information, which is INPADOC.
Mm-hmm.
So, which is hosted by European Patent Office. So, SpaceNet is one source for that. So, I'll run you people through that particular source and give you some tips how that can be accessed, and you can do a patent analysis of your interest, and that actually covers more than about 100 plus countries patent data, and
Mm.
then some tips on patent scope of WIPO, World Intellectual Property Organization, if time permits. So I think that is the general structure. And
But sure,
let's start.
before you start, can I just intervene for 1 minute?
Yeah, please.
Initially, I had written in the mail to all the speakers that at the end there will be question and answer session. But since
Yeah.
yesterday the speakers have requested that you let them be unmuted, and in
Uh-huh.
between like 20 minutes, 15 minutes, let it be interactive. So all the participants are unmuted, so you can interact.
Okay, fine. Thank you.
This is
So
the change.
I think all are open. Anytime they can stop me and ask question. No issue.
Okay.
That would be great actually. That's
Okay.
just more interactive and useful session. Uh, so you all witness this pandemic, and I think this unlocking is now going back. There's some technical issue in the slide. So we are actually running in the phase unlocking 5.0. But with this unlocking, let's unlock intellectual property rights and let's specifically unlock technical information which is available in patent documents. So that would be my motto, that you should be able to unlock intellectual property rights, or not rights, unlock intellectual property which is hiding in patent documents. And I think you should unearth and utilize that knowledge, and that I think is an right source to become Atmanirbhar. Uh, the clarion call of Prime Minister, and then patent information can definitely help you because all the technical information which is available in patent document is not necessarily proprietary information. Uh, More than 90% have fallen into the public domain, and you can utilize that patent information, the technical information, not only for your research and teaching purposes, but you can have your startup in place where you can utilize hundreds of patents because they have expired or not protected in India. Uh, at the same time, you can do value addition on those inventions and technologies to have your niche and specialty and protected area in the technology sphere. So that's how I firmly believe that can definitely help you making Atmanirbhar. Not only you or you're a startup as Atmanirbhar, that contribution can lead to whole country as a Atmanirbhar. So once again, I request you to put mask on and keep social distancing. And I think Vinita, in specifically arranging this FDP, the social distancing or a E, uh, uh,
Observing the real social
X.
distancing.
Yes, yes, great. Uh, so with this, with these initial remarks, let's move forward. And when we talk about intellectual property rights, see, at the same time, I serve two purposes by showing this particular slide. Arogya Setu app, I think all of you must have installed and maybe using this particular app. But if you look at the back end of this whole story, a lot of IP has gone into it, and many times we feel that can such software be patentable? But if you look at this particular Arogya Setu app, it has Bluetooth interaction with different devices, and then it's not only a software, but it is a combination of a hardware and a software. And few tens of patents would have gone in this. So those will be unearthed a little later, or people would not have protected in the hurry of making it for the public use. But now next stage for this, people wanted to have this Arogya Setu app functioning on feature phones, which are used in rural areas who do not have access to smartphones. So still, a lot of inventions are required to make this work on feature phone. So you have that option open to contribute to this particular cause and have your own patents and look at patents which are facilitating a functioning of Arogya Setu app. And all those patents would be relating to Bluetooth and interaction of different devices using that Bluetooth network uh, and the data sharing and different algorithms attached to sharing of those datas from network also, because the centralized data access has to be there to find out who is infected. So with this introduction, I would like to recall working in TIFAC. We worked with Dr. Kalam initial years, but what he used to say, thinking is a capital and enterprise is the way and hard work is the solution. I think if we follow these three steps, pandemic using patent information will take us long in really becoming self-reliant. So when we say how IP helps, and then it is not only for protecting your creativity, making use of creativity embedded in products arising out of protection and publication, uh, patenting and patent publications. So we will not go in individual IP because topic is the patent search. I would like to straight away move on to the patents. What is patent? I think you had session yesterday's about introduction to IP and then detailed introduction to patent system also. So patent is monopoly rights granted by the government for limited period. But what for? Why this monopoly right is granted to you? Because you are disclosing complete technical details, mean total workability of your invention in the patent document. So there's a possibility that that may be totally new product, that may be totally new process. Uh, in most cases, it's the improvement in new products or improvement in existing products or improvement in already known processes. So all those new product process and improvement are getting protected through patents, and that protection is provided to patentee in lieu of this particular disclosure, and this is published in the form of patent document. So all that information which you disclose to government, that is published by the patent office in the form of patent document, and that publication happens after 18 months of filing of your patent in normal circumstances. But if the applicant or a patentee wish to get it published early, there's a provision of paying fee and get it published within 15 days or a month. So you file patent today, it can be published within 15 days to 1 month. If you pay extra fee, in normal course, it is published after 18 months. So many fears of uh, aspirant of patents that the patent office will leak the information, or that information will reach to other people. So you don't have to worry. Anyway, legally it is supposed to be reaching to everybody, and all the technical information which is being disclosed to patent office going to be shared with whole of the world. And at the same time, we will be able to have access to the technical information in patent documents filed worldwide. So we also will have access to all technical information uh, put in the form of patent document around the globe, and that access is also free. We don't have to pay for accessing that particular information. Uh, so if we look at how many patents are filed worldwide every year, it's between 3 to 4 million patents are filed around the globe. And when you go for your research publication, you have to assign the copyright to a publisher. But in the patent document, it's an open document, so anybody can access freely. In your publication, you may not be able to access your own information without paying beyond certain copies or certain purposes. But patent document, you and everybody would be able to access. So I firmly believe that that may be a better publication of your technical information, and that will be examined by the patent office for patentability, and patent will be granted to you after thorough examination and assessing whether that is novel or not. And another thing, another nature of this patent document and patent information uh, makes very, very important, because whatever technical information you are disclosing in patent document is supposed to be complete and uh, sufficient enough to work the invention. So if you are claiming something, then it should be sufficient to uh, work the inventions. Means you cannot hide uh, much of information which you may not publish when you publish papers in journals, because you don't have to disclose the complete uh, workability of invention in those papers, because you can actually describe outcome in those papers, and you can have a backup with scientific principles and some experimental data. But in patent document, you will have to uh, disclose all the examples and experimental data. Failure you may not be required to be, but all success which can make invention workable, you have to disclose. So in addition to the technical information, what kind of information you would look in patent documents or a patent databases are who owns that particular invention in the form of patent, where that patent is valid. So the territorial jurisdiction of enforceability of that particular patent can be accessed through these. And when it will fall into the public domain, means when everybody will be able to use that invention or a technology free of cost. So that is expiry of 20 years, or people stop paying renewal fees after certain period. Okay, so then it will be for public. But I think when I saw list of participants, most of them are from academic institutions. I can make one important point here, that any technical information which is available in patent document can be used freely for two purposes. One is for doing further research. So if you want to improve any invention which is covered in patent document, you can freely use that for research purpose. If you want to teach your student analysis of a patent information, or the technical information which is available in patent document, then also you don't have to take permission from patent holders. I think somebody wants to ask a question. There's no question? Okay.
So far
So
as now, I don't think.
okay. So for these two purposes, you can use technical information available in patent documents freely. Now this is whole cycle of a patent information. Uh, but the problem with patent information is very interesting. Most of the time, it is written by patent attorneys. So this is a techno-legal document. So the way of writing is little different. It's, though these are not written the way you are habitual to write your research papers. And see, if you look in to patent documents, how they will write, and many a time when I send final patent documents drafted based on invention disclosure provided by inventors from academic institutions. So they always say, "Oh, this is what I invented," and I think we need to make a habit of reading patent document. So this is actually in a standard format. Once you have read few tens of patents, I I am confident that you will be able to understand the technical features which have been covered in these patent documents, and you will be able to understand technology behind uh, all those inventions which are protected through uh, particular patents. So how you look at, most of the time when inventors come to us, they will say, oh, this particular problem was there, we were importing this equipment, I have made 100 times cheaper than the import. But if it is because you are getting access to cheaper raw material and you're making it cheaper, that will not fetch you a patent. That there has to be a technical advance, and all these benefits and all will not be patentable. So why I'm mentioning this, because when we go into patent documents, we should be able to understand this particular language. As the optimist would say, the glass is half full, and the pessimists say glass is half empty, and our prime minister says it's half filled with air and half with a liquid material. And that's the way most of the inventors described this particular glass, which they have invented or they have innovated. But the patent attorney will say it differently. They'll say liquid H2O bisect an open cylindrical vessel and not. And then at the next stage, infringer will come and say, oh, this glass is not cylindrical, so I can copy this patent. So that's how you are supposed to be careful in uh, patent document. So let's see which all are sources of uh, patent information. So let's look at some of the official websites where you can get country specific access to patent information. So this is the Indian Patent Office official website, ipindia.nic.in. I'll be sharing slides as requested by Dr. Vanita. So you will have access, so you don't have to note down or annotate at this moment. Then this is official website of United States Patent and Trademark Office, where you get access to all the patents for last 200 years, 200 plus years. And then this is worldwide spacenet.com. It actually contain patent information for more than 100 countries. And I think if you are a beginner in a patent searches or a patent information, I believe accessing these four websites or a free website will serve your purpose, and you may not have to subscribe to any paid databases till you seek an advanced patent analytics, or you have a very high stake of invalidity or patentability or a very cutting edge. So that you can leave it to professional to suggest you that your invention is novel in light of that. So if it is a cutting edge and high stake thing, I think you leave it to professionals. But for your purpose in academic institutions, if you are able to access these 4 free patent databases, and I believe it will serve your purpose. So this is how this. So we'll look into a real patent information, patent document. So I stopped sharing slide. We will talk about this methodology and further slides little later. Uh, but let's look at patents. Are you able to see now?
Yeah.
This patent office website is being seen.
No, no, no.
Okay. Okay, so let me change what I'm sharing. One moment, give me a moment. So I have to share this. Okay, now you're able to see?
Yes, sir.
Now all are able to see this website,
Yes, sir.
which I.
Yes, sir.
Okay, okay. So this is an official website of Indian Patent Office. This is called ipindia.nic.in. And what we can go to the public search here. Public search, then you will come to this particular page. So this public search is available for patents, it's available for trademarks, it's available for designs, and there are others. So we'll not go into that. So let's straight away move to patent searches. So if you move, you will be taken to this particular page where you can search in Indian patent data. So this website will provide you access to patent filed in India since 2003 plus patent granted since 1911. So you can choose, you want to search in patents granted or you want to search in only patent filed and published by patent office. So there are options. Okay. So now let's say we are searching in patent published. Then you have further option of selecting fields. So you can select publication date or application date or date of grant, priority date. So you can actually restrict searches by some date. So if you're not putting here, it will search in all the fields. And not restrict, it will not be restricted. So you can search for last 2 years starting from this date to this date. So patent granted from 2010 to patents granted maybe by 2017, 18 or till date. So that you can actually specify the time frame. So let's not define that. Then you can search in abstract of the patent document. You can even search in complete specification of patent document, and you can search by inventor's name if you know patent. If you want to search patent in the name of SNU, you can do it. So so all these options are available to do a patent search. So let's try and start a preliminary search. Let's say you now in this pandemic, we may have some invention. Most of the people worked during this period, ventilators, masks, vaccines, and the medicines for treatment of uh, COVID-19. So these 4 were the hot topics for last 6-7 months. So let's look at simple, like you do a Google search. So if I say mask here, then I have to go here, but this patent office always asks you to fill this captcha. So this is 80Y0X. So I say do a patent search. So there are about 1350 patents have been published in last 15 years or 18 years with regard to masks. But see, this will not understand what your masks, so they compute only if wherever there is a word mask used in abstract, it will be, so it says a power generation face mask, smart face mask for corona patient using IoT. Okay, so at the moment we are familiar with this 2-layer mask, 3-layer mask, and surgical mask. Can you imagine for the corona patients, a mask is using IoT? So what is this smart face mask? So we can look at this. So if you want to go into further detail of this particular patent, let's click on this. So you'll have all details. It says invention title is SM. This they have given a name. I think this can become a very good trademark also a little later. So it is SFM, Smart Face Mask for Corona Patients using IoT. And see this, when I'm searching my keywords, so keywords can be different in different territories, like in US or Europe, the same word, not mask, but some other words like cellular phone. Some in countries people call it handy phone. Some countries they call it cell phone. Some countries call mobile phone. So the word will not help us. So for identifying that right kind of information, there's always a system called International Patent Classification Numbers. So this is having classification number A41D 1311. So this is 5-level classification system, and the field of invention is they have mentioned as a textile, and it is done by individual inventor, and they themselves are so these are the claims of this. This is a novel framework known as a smart face mask using Internet of Things for corona patients. This invention is made such as face mask, breath sensor, respiratory, machine learning algorithm, and mobile phones to realize remote health monitoring. So when you, as a corona patient, if you are isolated, so this face mask will monitor your health in real time and will interact with supporting equipment, including your breath supporting system, means ventilation or ventilator system. So let's look at this. So we can not only see the application, but we can view all the documents. So we can see this is a sequence listing is also there. Then they have made a early publication require, and this we can see the drawings of this patents also. So how this this has been designed. So this is an algorithm, how it works. This is the whole patent, and then they have given, because this is not a standard format in which patent drawings to be put in. So there will be a formal objections from patent office when the patent will be taken up for examination, so that we can see in a standard document. So this whole system they have designed. So all the information, technical information, is available in the patent, and this patent was filed in 2020, and they have made request for early publication. So the 1st of August, and it is all available on internet with the complete document is also available. So I'm just showing you the complete. So everything is available in the background of invention. So you can have access to the complete technical information, and they have cited few related patents. So if you get access to one patent, in many cases you will be able to know all related patent to that particular patent, because that inventor would have definitely done patentability analysis, and for the sake of easy defending of those patent when they go for examination, they will incorporate all those patent document or a reference to patents in their patent document. So patent office, when they examine them, they will understand that this particular invention has already been differentiated from inventions covered in following other patent applications or granted patents. So that's how you can look at the complete patent. So this is not a very standard format of filing patent, because that's how I just wanted to. So this is complete specification. So I will, okay. So we have come back to here. So again, we will go there. Let's say we said mask, and then let's say in mask particularly, if my invention is not relating to a smart mask, or my invention is not relating to uh, uh, other features, and is actually, if I have put between two layers of a cloth, let's say a filter, then I can restrict my search mask and let's say filter, and let me see with the HEPA filter or what kind of filter. Okay. So if I use the way we use in Google, so in place of 1300, we are getting 11,000 patent. And why it is? Because if I say mask and, so it, and in this website is not taken as an AND operator. So what to do? Then let's go back. So we say in abstract, we say mask, and then I say AND. Then in again abstract, I say filter. So if I put, as we do Google search here, it will, whether you type AND or anything, it will take as an OR operator. So these operators are very important. So you really have to understand and use right operators. So if at the first time you give mask and filter, you type it and it takes an, so in any patent, if filter word is there, or if any patent mask word is there, all will be displayed for you. So that is because we were using incorrect syntax. So to really understand the correct syntax, I always advise people to go to help menu and see what all facilities this database has to have a right syntax. So if say it says the asterisk sign represents 0, 1 or multiple character. So if you put asterisk before the word or after the word, it functions as 0, 1 or multiple characters. So why 0 or 1? It may be in date or a number where you're considering. So this, if you put asterisk, it means it can be computer, computers, and so that's how. And then if you put this particular figure, represent a single character. Let's say if you have using searching for color. So Americans will write COLOUR, no, LOR, and the European or British English, they will write COLOUR. So in place of that U, if you use this particular mark, this will function as single letter wildcard. So how these marks to be used? How the syntax is to be built, how these operators and or etc. will function, you can look into this help menu. And why I am emphasizing this, because this is different in all different databases. So if you go to Indian Patent Office website, these marks, the star marks. So if you go to USPTO, the asterisk mark will not be used as for this particular purpose. They are using a dollar mark for the same purpose. So all these wildcard characters are very specific to these database and the tools available at the back end and at the front end, both. So those are designed based on what tools they are using at a back end and how and what kind of tools they have deployed to access at a front end and present before you. So each of these, I just leave it to you to go and look at these. So there are fields. So Indian Patent Office has come up with classifying them by fields also. So about 14 fields they have classified. So this they have put in complex query. So I think I have spent adequate time on this to showing it, and you can do search in multiple this thing. At the same time, you can select patent granted, and you can have searches in granted patent documents, Indian patent documents. So actually, after 2005, only in granted patent document you have access to full text. Prior to that, uh, even prior to 90s, if you know the patent number or then you can really access patent from 1911, and if you can search in title also for all those patents. So that possibility is there. And then on the same website you have e-register of a patents, where you can uh, find the status of that particular patent, whether it has renewal fees has been paid or not. You can find the application status. So let's look at some of the granted patent, one granted patent, and let's look. I'll not go for the complex search here. I say ventilator. Simple search. So we'll just practice. So that if I say ventilators, there are about 66 patents which have been granted and have been filed recently, and the latest patent which have been granted, patent filed in 2017, lung cleansing apparatus and method. So it was filed in 2017. This is the application number. It has been granted. So you can go to e-register of a patents and can check the status. So this is the patent number. This is the date of patents is always date of filing of a patent application. So it was filed on 17 September and it was granted on March 2nd, 2020. This was ordinary application. So these were the people, and then they have renewed this patent till 17th March 21. They have renewed, they have paid the renewal fees. So here you can really find out the status of a patent, whether this patent is valid or not. Same way you can look at all documents, complete documents. So you can view documents here, even what kind of objections were raised by patent office. You can see in the first examination report and how those has been responded by. So this is a response to the objections raised by patent office. So this whole process of patent filing, granting, everything is transparent and is accessible to all of you. All this I'm talking about Indian patents. So all Indian patents are accessible to you. Yeah. So this is how you can look at. So when you file patent, you will also know how to contest and how you have to give proof, how you can prove what you have invented is different from already existing patent documents or a technical information available in any other uh, document which have details of inventions, which have details of functioning of machine, which have details of a material, which have details of a process arriving at new products, algorithms, and different machineries and the functioning of those machineries. So how those can be differentiated, uh, you really can see. So this is how the patent attorney job is and how they argue for you. So each of those objections are responded here. So this is all these documents you can have access on the patent office website, and not only your own patent document, as for anybody. So all patents filed which have gone through patent filing examination and granting process, all correspondence are open to you for free access. So this I have spoken to you about Indian patents and how we can access patent filed in India and patents granted by Indian Patent Office. So this only covers patent data of uh, Indian patents. Means in India about 50,000 patents are filed. When I say Indian patents, is not meaning that patent filed by Indian, but it includes patents filed by foreigners in India. And you may be surprised to note, some of you may be surprised to note that as patent filing by Indians in India is a bit something between 20 to 30% only in last few years, and then 70 to 80% patents are filed by entities from other countries in India. So that's the ratio within which, but only these Indian patents are valid and enforceable in India. So any patent document or an invention which is not covered in these Indian patents, and at the moment 50,000 patents are filed every year in India, but total patents in force in India at the moment is around 50,000. So it's not only here, but all patents filed in last maybe 20 years, about 50,000 patents are in force. So all other patents means if we are running at 3.5 lakhs, patent number 3.5 lakhs, so 3,44,000 or 46,000 something. So only 50,000 patents are in force, means all 3 lakhs patents in India which were granted at one point of time all falls in public domain. Patents which have not been granted, inventions covered in those patents are in a public domain. And other than only these valid 50,000 patent, all 30 lakhs patents granted every year, or 500 million or half a billion patents available in patent documents are available to us for free exploitation, and that include commercial exploitation also. So let's close Indian Patent Office website or Indian Patent Search here with this quick note, and let's go and look at how US patent system works. Uh, this is United States Patent Office official website, which is uspto.gov. Here also you have option of searching trademark, you have option of searching patents. So here you have again patent file as well as patent granted also. So let's go to a patent search here. So this is a quick search which you can do. So you have option for quick search, you have a option for advanced search, and then you have option for patent number search if you know the number. So here again, let's say I'm saying mask as a keyword I'm using, and then and I can use word and or and not. So and then I can search here. So I can select the field. I can search in title. I can search in abstract, patent number, etc., etc. Then international class, PCT application, other reference, and then claim is very important part. So if people have claimed anything relating to mass, so I'm searching is here, and then I can save. Then period is important. 76%, 1792%. So I say because 1790 to 1976 you cannot search in all fields, means you cannot search in claims. You can search only in title, and if you know the US classification numbers, then you can search from 1790. So let's say search in this. So if I say mask in claims, about 1,06,000 patents are fetched. 1,06,000 records fetched. What are these masks? It says surgical masks. So this has US patent grant. They have a numbering system. So I'm searching in a granted. So RE means re-examined patent. So this patent has been re-examined and given another number. And it says this D. So any number in US patent start with D. It is not a technical or because in India, yesterday you must have come across that India you have a normal patents where you protect your technical features of your invention, and other is design registration where you protect external appearance of any articles. But in US, for this design registration, there is no design registration process, but they call that as an design patent. So the design patent number starts from a D, and it means it only protect external appearance of that particular article. And then this surgical mask as a design patent is protecting external appearance of a surgical mask and not technical feature of the surgical mask if the number start from a D. Okay, and then all other are the technical patents. In US they call them a utility patent, but those are not patty patent. And now if you look at this mask, okay, it says optical sensor with ambient light filter. So what do you do with light filter in your mask? Has output manipulation. It means the word mask would have been used for very many different purposes. See, if I say system and method for matching electrode resistance in OLED. So here it may not be mask which we are using on a face, or so it may be masking some signals, or maybe different mask used in a different technology domain. So when I say 1 lakh patents all are relating to this face mask, no, those are relating to, now we really here can identify our patent classification where these masks are used for specific purposes. See, if I say printed circuit board, so there are two options. You would have seen you can use and not option. Okay, so I say I don't want any electronic component. So what I can say, I say and not, and then in a specification I say electronic. This is again very little rudimentary. Let's see what the, so I'm redoing it. So the searches can be So in place of 1 lakh, now you are having 70,000, 77,000 only. So in all those patent documents, the complete specification, electronic word was used, have now been excluded from search results. But very interesting, printed circuit board, in the complete text, this electronic word is not used in the complete specification. Very surprising to me, as well maybe to you. So again, we can look, the electronic word is not used. What point I want to make here, when you do patent searches, these kind of keyword cannot be used like electronic, a machine, a device. Those journal word to be refrained to be used as a part of detailed search strategy, because when the patent documents are written, they may or may not find place in those documents and will not reflect the technical area by themselves. So we will have to go to very specific keywords in designing our search strategy. And till this time, what search strategy I have used, I have done search the way you generally do at Google. And see, Google searches, when you do Google searches, those are assisted with a lot of algorithms or AI behind that. So if you put sentence, or if you put, so they are actually empowered with the searches by natural languages, uh, um, some kind of AI which actually analyzes what you are searching, and appropriately they will devise a strategy at a back end, and results will be shown to you after that back end analysis. But most of these patent databases or tools will not have those kind of backup or tools which actually summarizes or uh, do work at the back end to fetch you a right kind of patent document. So it is not there, not there. So you have to manually work on those things. So like as I shown you a help menu there in US patents also, patent office website also, there is an help menu. And how you access this, and help menu is very, very important uh, for any tool to be used, or you embark on patent search on any website or a patent database. You must look at this menu first, then you will be able to do right kind of uh, search, and the right kind of tools you will be able to use. So let's say if we want to search in specific fields, what are different tips? See, let's say you want to search in claims. So how you should do it? So let's say you want to search in claims. There are tips to do. Claims from both utility and design patents are included, and then I'll let you know how to look at. So here you can look at how you can put your queries. What are different formats of dates? What are different formats you can use for searching? Okay, so I would advise you to look at these help menus when you practice patent search and do patent. So let's come and look at the option called advanced searches. Okay, advanced searches as option, and I'm searching from so here if I search claims, then we need to learn these kind of words, where you will find I want to search in claims. So you can say in claims, there's a field code ACLM. So I can type ACLM. Okay. And then I will say again, let me say laser, and I'll say and what I'm doing using this laser for treatment of ACLM. I'm treating my eyes with laser. So I say this and then just okay. So now it's saying this semiconductor laser and method of producing such as semiconductor laser. So when you making laser devices which can be used for eye surgery, then those will also be displayed for you. 3D scanner and artificial object processing device using the same. Infrared eye tracking in high ambient light conditions. This is apparatus for eye laser surgery and method for performing the. So let's look at this particular patent. What is this? And who? Okay, so this is apparatus for. Okay, now here, if we look at, it has been classified in these many classes. Let's look at one of these classes. What are these classes? These classes will help us in doing kind of a patent search. So I say we can go to International Patent Classification or a cooperative patent classification CPC. So we can really understand. See, when you go to library, I just paste it here. See, my class was A61B3425. So what is A61? So let me see. A61 is medical or veterinary sciences or for the hygiene. So it's just a medical sciences. And then if I say A61B, A61B is diagnosis, surgery, and identification. Okay. So the moment I say A61B, it is surgery, diagnosis, or identification. So what I can do, I can go back. I was looking for the laser surgery. Then I say laser surgery, laser, and let's go back here. Now ACL claim, I'm saying laser, and then and I'm not saying, I may say I, or I don't say I say all devices for surgery. So where laser is not only eye surgery, is used for surgery. Then I look at International Patent Classification. What is the code here? Here I have to find out the code. So filing date, this is re-examination, other offers. So you can see this is current patent classification or international classification. Code is ICL. So what I say, ACLM laser and ICL is B. This is B61B. Means now what I'm doing is I'm looking at laser in a claim, and then I'm looking at all surgical devices. So if you look at this, it says A61B is diagnosis, surgery, and identification. Okay, so I'm not going further down because we can go to next level of understanding classification A61B, and then we had 3 a part of testing eyes. So if it's I want only eye testing and instrument for examining eyes, not for the surgery, then I can say 3. So we'll understand this later. Then I say this. It means A61B. And then if I search, my patent, I'm getting one patent only. This is ophthalmic measuring method and application. Where it is laser is in a claim. Then it says measuring method for which optical system is used to project a laser beam and select spot in patient's eye, and the laser light scattered therefrom and detected the ophthalmic measurement, and comprising these are the steps. Okay, so here also you same way you can look at complete text and images. So this is how you will be able to see a complete text or a full text of that particular patent. So you can combine keywords and you can combine patent classification numbers for more precise search, because technology areas you will not be able to select or narrow down by using different keywords, because different languages, different expressions, the use of different synonyms, etc., etc., will not fetch you right results if you totally depend on keywords. So this is how this would, and how do you look at this document? In these patent document, there's another thing, these numbers 11, 45, 54, 75, 73, these are international numerical identification numbers. So in any patent document, whether it's public in Japanese, Chinese, 54 will be a title of an invention. So if you are having a Japanese patent document in Japanese language where 54 is written, you can translate that particular portion of document and you will be able to know the title of that particular invention. So this is how on front page, this is a front page information of any patent document. The formats maybe differing in different countries, but this is generally all these information will be there. You will have a patent number, date of patents, and the international classes, then US classes. Okay, then there will be a drawing. So all drawings relating to that. This is how the laser device is focusing laser beam on eyes and measuring that ophthalmology of a particular eye. So you can look at this document page by page. This is so this was a front page. Then there is a section called drawings. You can go page number 1 to 10. So page by page you can move. So here you can click and go to next page. So this is now on a page 3rd. So you can see each page of this from the patent document. So this is how you can navigate. So all images, experimentations are there. So these are the figures. This is how you're supposed to put figures in, and then each patent office will have its own guideline how. So you have to be put in. So this is how you can navigate through US patents. So I've just introduced to you international patent classification. So when you go to library, there's always section of mechanical engineering, then electronics engineering, biotechnology, and within those sections also, if you go to electronics section, there may be microwave electronics, there's the components. So if you go to microwave particularly, then there may be a section books on antennas, There's a section on passive devices like that. In patent documents also, mm, the classification has been done. So I just would like to introduce you to this, the whole scheme of IPC classification. So I will remove this and we'll take you to the main. So the all area of technologies have been segregated in or classified in 8 sections. So this is the first level of classification. And these 8 sections are human necessities, performing operations and transporting. So if I say performing operation, measuring something, let's say polishing something. So any operation you're performing is covered under B, like the shoe polish or measuring a distance, maybe electronically or any means. So those are classified by these numbers. Then if you invention relating to physics, it will be G, electricity would be H, mechanical, etc. will be F. So this is a first level and it will be represented always by a alphabet. And let's say performing operations. So I go to B. So B is include transporting. So I can go and find out what kind of classes are further there. And the second level of classification will be 2-digit number. So it is 0, 1, 2. This is not fixed in all like C or D, etc. These numbers will prevail. So each classes there would be different. So what I'm saying here, let's say, so B05 is relating to spraying or atomizing in general. So see, now spraying or atomizing in general. So that applies to liquid and other fluent material. And can you see the application of this class at the moment? Yes. So this atomizing the sanitizer. Atomizing the sanitizer. So all those devices which perform this operation of atomizing of a sanitizer is a, so can we look at different kind of atomizer for sanitizer? So in that case, what I can do, I can choose this particular class B05. So let's just go further deep into this, how further next level this classification would read. So when I say so when I say if I click here, then I go to the 3 types of atomizing will. It says spraying apparatus. So if atomizer is spraying apparatus, so that spraying would be like you're spraying pesticide on a crops. You have those fogging machines, and then atomizing apparatus. Then in that also particular nodules for spray mixture. So if you're mixing 2 or 3 different liquids, so the nodules for mixtures or spray mixers. So for that we may have to go to the next level of a classification. So and then apart from applying liquid to other, so one liquid is sprayed on other and mixed or like surface treatment, etc., etc. Like if you want to uh, material to the surface, if you want to paint your car, if you want to paint your wall, then this particular class B05C would be used for spraying and applying the liquids. So spraying apparatus. So the atomizing process is used for what purpose? So those devices can be identified. So these classes can be used. Let's say this we wanted to see the spraying apparatus. So let's look at further down the next level of a class. When I say 01, so 0, now this say B05. B is atomizing and then this is nozzle, etc. etc. So if invention is relating to nozzles, spray heads only, then the class will be B05100. So if it is sprinkling apparatus, which is generally used in agriculture, so your atomizing is used in agriculture for sprinkling this thing, or some other purpose. Then your invention is relating to this particular class. So let's copy this class. See, then it is. So if the sprinkling is by rotating elements, or is driven by the liquid or other fluent material discharge, mean this sprinkling mechanism is driven by liquid or fluent material discharge. So when this liquid material is going out of that particular device and it rotates, and which you are seeing in your parks when it is you watering the grass in nearby park. So let's look. So this is class for that. If it is sprinkling devices are governed by discharge of that particular material from that. So this is governed by discharge of water in case of water sprinklers. So class for that. So I may not use any patent or a keyword. So let's look at now. So I was talking to you about SpaceNet. So I can go to advanced search, and I'm not searching here. I go to the classification. Okay. So I copy this class here is B05B. Okay. Let me see. I see B05, B03. Then I say search. So now you see, this is operationally changeable multiple nozzle sprinkler. So here I have not used any keyword now. See, keyword, you cannot use all synonyms, you cannot use all possible names, you will not know the psyche of a person, how he is writing a patent document. So in all those cases, if I am using this international patent classification for patent search, then I don't have to use keywords in all the cases. So my search, let's look at the results. This speed control rotating sprinkler. So all these patents, shower head with a water driven vibrator to provide. So see, the sprinkler is described as a shower head also. This is shower head. So sprinkler word is not used in this particular thing. So if you would have used word sprinkler as a keyword, this patent would not have been in your search output or search results. So that's why it's very important to use International Patent Classification System or Cooperative Patent Classification for doing a patent search. So how do you find these classes? So that would be, first you do a search using keyword, locate all relevant patents, look at how they are classified, then you can go to classification definition and can you will be able to okay, one moment. Okay, now here what you can do, you can short. So you have about 4,000 patents which are relating to that sprinkler nozzle or that sprinkler head. So that the device. So I'm now at a fifth level, the final level. So these are those head for atomizing. So all patents are relating to the final. It's not to the complete machinery, but inventions are relating to that. So what you can do, you can sort them by relevance. This you can sort them by priority date. You can sort them by publication date. Okay, and then you have more options. What you can do, you can download them in the form of Excel sheet. So if you click there, about 500 patents will be downloaded in Excel sheets. So if you want to download these 4,000 patent documents from EPO, 1 to 500, 500, 1 to 1000, so it will be downloaded in Excel sheets, and you will have all 4,000 patent in your Excel sheets. So I think there are 5 minutes left with this. Vinita, I think, do we take 5-minute questions rather than going on like this? You muted, I believe.
Sorry.
Yeah.
I'm muted, right? It's echoing my voice.
Maybe you must be connected twice or something.
Oh,
or maybe two devices. So, see, make
So
single
should I-
connection, Nico will not be there.
Just bear with me.
No issue.
Okay now?
Yeah.
Okay. So I have few questions in the chat if you could take up, and I think it was very, very interesting, and you're explaining in such simple terms and in very contextual terms, taking examples of current times. So I hope, but the participants, I'm very surprised they're not coming up with queries and questions as if you're really into it, or maybe you're too scared to try, because nothing goes simpler than this. Let me tell you, he's an expert in this area. So if you have to ask anything, please ask. Or else I put up your questions. Class, what do you say? Hello?
Yeah.
Yes, Professor Vanita, it is all very clear that we are also trying it here in our internet.
Very good.
Yes.
So
We
I
tried
think-
few websites. Yes, we tried few websites and we are following his instruction.
Excellent.
So, Mr. Yashawant, it was very, very nice, and it was actually a very good hands-on training.
Okay.
And this is regarding the patent that we wanted to search, and I just have one question. So if it is like so many steps in searching patent, and I think filing the patent would be even more complicated, right, sir? So we require to take the attorney's consultation before filing it?
Yeah, that's always advisable, because if you look at the language which I
Yeah, that half glass of water, H2O, yes.
Yeah. So that's where the professional help is very. You are working where?
I'm working in Chennai with a very renowned college, DG Vaishnav Varumbakam.
So if you want to file a patent in the name of college and you've done invention in college, you can send your request to us. We can bear all the expenditure of patent attorney, including fee also. And we
Thank
have
you, Yashwant, because we are working towards this NPA. So we want to have an IPR cell. That's why I very particularly registered with Dr. Vanita. I'm sorry, Vinita. Yes. So that was our purpose. I think we can go for patenting this logo designs and those things, right? Because it's an arts and science college.
I firmly believe that Dr. Vinita, after the training program, equip you with differentiating between logo, trademark, patent, and different forms of IP.
Yes, Yashwant, it was very nice. It was
Right,
very nice. I'll take your help, surely. Thank you.
Okay, that was very nice. At least it was a platform for connecting also. So, Dr. Yashwant, I just put up two questions from the participants. One is from unknown user. It says the question is, it says a reference to your quote of 70% of Indian population should be actively using Arogya Setu for it to be effective. You said that. But the attendee feels...
I have not used 70% population should be using. But most of the people are using, yeah.
So the attendee says presently uptake appears to be far less. In this slide, is there any data of any patents granted to startups building products on top of Arogya Setu?
At the moment, it is not. But see, if they have utilized patents or patented inventions, it has no issue have been racked up till. But there may be some issue because of the pandemic. People are not taking those issues to litigation or anything. Definitely, there are patents which are being utilized by this.
Okay. Another question is there any special track for filing in which women is an applicant? I don't think there is any gender.
Now, see, if any patent, if one inventor is women, then I think there's a fee reduction and an expeditious publication. So the government of India has come up for a special privileged where there is a one women inventor. So this new scheme can be seen. Yeah.
But there is no different track.
No different track. Track is only in the form of processing and a fees.
Another question is a very basic question. What is the main difference between applicant's name and inventor's name in a patent document?
Yeah, so it's a very good question, I believe, and this is very pertinent for academic institutions. See, inventor is an inventor. Okay, so you can have any organization as an applicant, and even inventors can be applicant. So in one patent documents, if you independently invented of any organization, then in that patent document or patent application, you will be inventors as well as applicant. Means applicants are owner of a patent and inventors are inventors of that particular. So inventor's name would appear irrespective of a owner of a patent. Let's say you are working in a college and utilized college lab for inventing that, and as per your service agreement, college will be the applicant and your name will appear as an inventor. So if you leave the college also, you will remain to be inventor in that particular patent application. So, but all the rights of transferring that particular patent will vest with the applicant. So applicant will be able to license, applicant will be able to sell the patent, applicant will be able to collect the royalty. But how inventor is going to benefit it is as per the relationship between applicant and inventors. But if the invention is not done under any obligation, then inventor themselves can be inventor as well as they can become an applicant. So that is the relationship. I hope it is clear. If still doubt, you can unmute and discuss.
Thank you so much, sir. It was very nicely explained, sir. Thank you.
Okay, sorry. So there is another basic question on difference between process and product patent.
Yeah, I could see that in the chat. Yeah.
Okay, if you're watching, it's fine. Then I'll not read out.
Yeah, that's. I think no. You can identify which is important because by I'm answering. Okay. See, product and process. There's a confusion. See, other than few areas, we had product as well as a process patent. Only certain areas like drugs, pharmaceuticals, where how you are making that particular product, those processes were not patentable. Now, the process of making that drug, process of making that chemical, process of performing method of performing some operation, including those devices, those final products. Let's say you have a paracetamol, aspirin, atorvastatin. These are a product per se. So you have a product patent. So if you have a product patent, means irrespective of the process you follow to make that particular product, you are infringing on that particular product patent. But if you have, you don't, the product is not patented by protected by a patent, then, or if it is protected, but there is a process of making that particular, so there is a chemical reaction takes place to make particular chemical. But this is not only one method by which you can produce that particular chemical. You can have 10 alternative method of producing that chemical. So there may be raw material difference. To save energy, you may have a catalyst to produce that final product cheaper. So each of these process will be, irrespective of a product, independent candidate of process patent. So product means the final product, like atorvastatin or aspirin or a paracetamol or and let's, for the purpose, any chemical which is protected by patent. So that's the difference between product and process, and other terms and conditions remain same.
Okay, another observation which is very, very commonly asked, yesterday also it was raised to Professor
I think Dr.
Jan.
Vanita can supplement to this answer, because you understand better than me the product and process, I believe, after your...
No, no, it's okay. So another question is, yesterday also they had asked why more foreigners apply for patent in India as compared to Indians, and less patent application in India.
Yeah, this is Ranpreet Kaur is asking this particular question. Ranpreet, see,
Yes,
patent is not for a documentation purpose. Filing of a patent or a protection through patent is not for documentation or having a patent number, but where you have a market. So the applicant from around the globe who wants to do business in India and don't want their inventions to be copied when they introduce those products in Indian market. So India has a big market, and then all around the globe, people wants to do business in India. So they want to protect their inventions in India. So it is not, I think this question which you have put up should be other way. Why Indians are filing less, rather than we say why foreigners are filing more in India. So foreigners should file still more than what they are doing it, but we should enhance our filing within India. And I think if we look at the global statistics also, if you look at US patents, in US also, so filing by foreigners and US applicant remain between 49 to 51%. So sometime 49, 51%. So 50-50 in US. So if we are 30, not bad. But people compare with China, they file 13-14 lakhs and 90% by Chinese because of language restriction, because of the quality of Chinese patent. So there are different reasons for that. But this seems to me is a 50-50 would be a reasonable proposition. But India being a large market, so if it goes beyond 50% by foreigners, again a good this thing.
Okay, can the management
I would like to
process
ask
also
one
be
more
patented?
point here.
Okay, sure. Please go ahead.
Sir, if this is the case, like in US, somebody has gone with the patent, and that same for same thing or same product or process, because he has gone for US, that person may apply for patent in India also because it is territory based. That can be also a reason.
Yes, yes. See, US patent is valid in US only. So if, let's say, US inventor and applicant file patent in US, they will not have automatic protection in India. Till they come and file in India, we will be free to copy in India. So because of a territoriality of nature. So they will file in US for same invention, they will come in India and file patent in India and get patent. But there are timelines within which you can do it. So you cannot come after 10 years and patent the same thing in India. No, it's not possible. Within 12 months you have to do it, or if you're coming through PCT route, within 30 months you have to do it. So if any patent is older than 12 months and no PCT application, it cannot be protected in India. If any patent is older than 30 months in US by date of filing, or any other country for the matter, cannot be protected in India, and we will always be able to freely copy. Let's say 30 lakhs patents are filed, 3 to 4 million patents are filed every year, and Indian total filing 50,000. It means about 3 to 4 million inventions are available to us for free use, including commercial exploitation. let's use that potential for commercial exploitation in India, rather than worrying why. So let's use this gold mine.
Okay. Thank you, sir.
And then there is a question, design search demo. I think there's no time for that. I think you can do. So US patent and design together, but design demo you can look at separately, I think.
Okay, another question is, can the management processes also be patented? Now, what is management processes? You have to specify.
If who asked if they can explain, otherwise I'll have to interpret in my own manner.
Meenu, are you there? Hello? I think she's not even there.
Okay, it's all right, but it can be interpreted, Vanita, in very many different manners. So various management practices like CPM pers or many things, if you are able to put in the form of devices and network of devices, definitely those business method or management processes can be patentable, but not in an abstract form.
Okay, they have to be in tangible form.
Yeah. The physicality of invention has to be there.
Okay, and last but not the least, it comes as a compliment to you, as they did for Jansen yesterday. Highly appreciated. And asking for email ID, should I share?
Yeah, you can.
So what is it, your email ID?
This is YASHA. I can share in the chat.
Yeah, please, you do it. There's one more question, Dr. Yashwant, if you can take it. We are teaching faculty what are the areas in which we can go for filing. So that depends on what you are actually working, in which area you're working on, isn't it? It's not that you're teaching, so you have to go for a particular filing. It's your domain where you're working.
Yeah, if you are able to devise some teaching, let's say, teaching aids which has a technical effect. Let's say if you're teaching maths and you have a very good teaching aid to teach
or
maths,
application?
that also can be a candidate. Yeah.
Applications like Baiju and all.
See, Baiju and all, if you actually integrate with devices.
Vedantu.
Yeah, so if those integrated with devices, there's a potential of a patent, and I think one should look into patent documents and Baiju and they file patent or not, and if they file patent, definitely. But such kind of things is definitely protected in some territories like US.
Right. So now that you've started this string of discussion, some more questions are there.
NIRF considered, I think, applicant's name.
Ma'am, I think Dr. Dhananjay Singh and Dr. G. Pratibali, they have some question. They have raised their hands.
Okay. So Dhananjay, please ask your question.
And Sandeep also asked.
And Sandeep also, yeah, please. I'm sorry, we missed you.
Vinita, what time your next session is? Because I'm not encroaching next
speaker's time. No, we have from 12 o'clock. So we have time. Okay. It is actually your time we are taking extra. So if you have no problem, kindly address.
I have no problem.
Okay, Mr. Dhananjay and Sandeep, could you please come up here with your question?
Yeah, Dhananjay Singh here. So, so the Indian Patent Office, how is it reaching to the vast majority of the small enterprises and encouraging them to file patents? First one, and second question is process patents. So, product patents, as we learned yesterday, that it's more important for the manufacturers, and Indian manufacturers had focused more on product patents to make it cost effective. But what is the focus now on process patents and versus product patents in the Indian scenario? Thank you.
Okay, see, for MSME, and there is a special money allocated by Department of Internal Trade and DPIIT. So they have awareness programs, they have a special concession for SME in the fees, and they have established, Ministry of MSME have established intellectual property facilitation centers for MSME. to help MSME to file patents. So there are different mechanisms put in place by the government, by two ministries for MSME particularly. And let me answer the second question of a product and a process. See, product patents and a process patent. Process is alternative way of making the same product. Okay, so that same product which you are making may be protected by patent or may not be protected by patent. So if you draw an advantage in making that particular product by devising another process, and you don't want that process to be copied by all, then you seek process patent protection for that alternative process. So that is more useful than the main product is not patented per se, or a patent is going to expire for the main patent. But if main product is patented, then it may have a less value, because the patentee of a product will not allow you to use alternative process. So there are different circumstances, but if with the patent is not affordable and through new process you make it affordable, or if you can serve a large need of a public because of change process is possible to produce at a with a high volume, then definitely process will have advantage, and product and process patent holder can come together and put that into the market. Yeah.
So I think that is the last question. Oh, Dhananjay Singh, do you still want to ask? Dhananjay?
I think
he's through. He's the one who asked. Okay, so I think we can wrap up the session.
yes.
Most of them have gone. Okay, so formally, once again, thanking you for sparing your Sunday and involving all of us in a very fruitful and interactive session. Thank you, Dr. Yashwant.
I think all have gone. I think
yeah.
Jagmeet and all three of us are there.
Thank you
All
so
have
much, sir.
Thank you, sir, for the session. Thank you.
Thank you.
Okay, the rest you
Thank
can
you,
exchange through
Yashwant. We
email.
will get in contact with you.
Sure.
Thank you, Yashwant. We
Thank
will
you
get
very
in
much,
touch
sir.
with you.
Thank you.
Thank you.
Okay, thanks.
Bye.
Thank you.
Bye bye.